Okay, so let me do one thing. Let me just download the PPT and I shall be sharing it.
Thank you so much. Thank you so much.
Just give me a second. Students, screen is visible, right?
Yes, screen is visible.
Yes, ma'am.
Okay. Ma'am, you can start with the lecture. The screen is visible on the screen.
Thank you so much. Hi, everyone. It's a pleasure to be here with you all. And I'm here to talk about the criminal drafting. Criminal drafting is an important skill. It's very important. It plays a very vital role in writing complaints, filing affidavits, writs, and application. It is the only way facts and law came together became before the court for the proper and just judgment of the cases. As you can see on the screen, I'm here talking about the criminal trial. Criminal trial is very important. Criminal trials is all about how we deal with the process and how we go after the accused. Here I'll be talking in both the language, in English and Hindi both, so that I can be very clear. And before going further, I want to ask you all that if I'm not audible, you can please raise that thing or raise your hands for that so that it can become a easier process. So, and if you have any doubt, you can please mention that in the chat box so that I can be helpful and I can understand that you are getting what I'm saying. I'll move forward. But before talking about the criminal trial, I want to tell you that criminal drafting is not something about law. It is about the facts. While going towards the criminal drafting, what we do is that we sit with the client of ours and we talk to him and try to get out all the facts out of him. But how should we do that? How to move forward with the criminal drafting? What is the process of criminal law? What is the process of criminal trial? We should be well versed with that. That's why I prepared this PPT so that what I will say to you, you can actually read that through the PPT and can come forward with me in this process where I'll be talking about drafting of a complaint, drafting of an FIR, drafting of a bail application, and drafting of a question of an FIR before the High Court. So I'll begin with the PPT. Page number 3, what is criminal trial? The criminal trial is when two parties, a prosecutor representing the government and a defense attorney representing a private person that will be the accused, meet in the court before a judge or a jury. Actually, now jury is not the process which we do or we conduct in India because we must be versed with the fact that Nanavati was the last case of jury trial in our country. After that, we don't conduct jury trial because you must be aware about the proceedings of that case, how a person who was actually accused, who actually committed a crime, but still get away with it because of the biased decisions of the jury. That's why after that judgment, when it goes to the High Court, to the Supreme Court, it was decided that now our country will not move forward with it. And therefore, after Nanavati case, we don't have jury trial in our country. Criminal trials is of three types: the warrant trial, the summon trial, and the summary trial. I'll move forward with the warrant cases. What is warrant trial? Warrant trial, according to Section 2, subsection 10 of the Code of Criminal Procedure 1973, a warrant case is one which relates to offence punishable with death. imprisonment for life, or imprisonment for a term of 7 years or more. That means these punishments are grievous. Grievous in nature where the hurt is more. The trial in warrant cases starts either by the filing of a FIR in a police station or by filing of a complaint before a magistrate. So there are two ways through which we file a complaint. Either it is through the police, we go to the police station, narrate the facts, what happened with us, and the police register an FIR, or the other way is we go to the court and we narrate the facts before the magistrate through the application of 156.3, and therefore the process goes on. Later, I'm now coming to the PPT. Later, if the magistrate is satisfied that the offense is punishable for more than 2 years, he sends the case to the sessions court for trial. The process of sending it to a sessions court is called committing it to sessions court. A session court is the most higher pedestal of the proceedings while dealing with the criminal cases. This court even gives the death punishment. This is a very serious court. So you must be understanding how serious a complaint drafted by someone can be, which is going to decide the death or life of a person. Even beyond the scope of the Constitution of India, which talks about life and liberty to everyone. But here, this code, this drafting, this law is much more than that, because this code, this this drafting, the case, the trial is deciding about the life and death of a person. This is something like what a god do to a person. This is very serious issue. So it should be dealt in that way only. Now moving forward, I'll be telling about the important features of a warrant case. Charges must be mentioned in a warrant case. Now, what will be the charges? Charges are the sections which are imposed on a person after the thorough investigation by the magistrate. This is done by the magistrate. Only magistrate has the power to do so. Charges are decided by a magistrate only. Now coming forward, personal appearance of accused is mandatory. In the private proceedings, I mean to say civil proceedings, there the appearance of both the parties are not mandatory every time. Their lawyers go to the court and conduct all the process, but in the criminal trial, in the criminal proceedings, the personal appearance of the accused is very mandatory. So now I'll be mentioning one draft which every lawyer need to prepare if the accused whom that lawyer is representing is not coming before the court, is that the exemption application should be drawn by that lawyer, that he is representing certain person, and because of this reason the accused is not present before the court on the date when the matter is listed before it. So the personal appearance is very important. A warrant case cannot be converted into a summon case. This is a grievous matter where the warrant has been issued, warrant to call that person before the court. So this is very serious, and that's why a warrant cannot be converted into a summon. Because in summon, although I'll deal with summon later on, but still I will mention it here also, so that you can understand and link with the chain between the warrant and the summon, is that summon is very grievous thing where the court want to actually see that person, that you please come, we'll see you, and then we'll decide what to do and how to move forward. While in summon case, it can be that person is at the liberty that today he wants to come or not. He can send an application through the council that due to this reason I'm not coming. That can be dealt with, but warrant is very serious thing. The accused can examine and cross-examine the witnesses more than once. This is something accused is having a liberty, some right. Because in India, while conducting the criminal trial, a accused is also having certain rights. Like in India, we always say that a person who is an accused is not guilty until it is decided by the court that the person is guilty. Until the decision of the matter, the person is deemed to be an, not an accused, and until he is not guilty, he is just a party. He will be treated like a party and he'll be having so many benefits which our criminal trial, our criminal justice system provides for that person. The magistrate should ensure that the provision of Section 207 are to include everything, all the charges, and how to move forward with the matter. 207 includes supply of copies to the police report, FIR, the statements, recordings, and other relevant documents to the accused. Accused should have everything. He should know what charges are implied on him and how he can move forward. Now, moving forward to the different stages of criminal trial in a warrant.
Ma'am, your voice is not audible.
Case. This will be something very important, and criminal trial is how it begins.
So sorry to interrupt you, ma'am, but your voice is not audible.
Yes, ma'am, your voice is not audible.
Is it audible now?
Now it is audible, ma'am.
Okay, fine.
जो
So,
आपने कहा था ना, we are moving to, तो उसके बाद से कुछ नहीं सुना मैम.
sorry, can you please repeat that again?
मैम जो आपने कहा था ना कि we are moving to, तो उसके बाद से कुछ नहीं सुना था.
Okay, now I'm on to something important. So I'll begin with this. I'm talking about the criminal trial and the stages. What are the stages in a court? How we begin with the trial and what we do as a criminal lawyer while drafting, because this session is all about drafting, what we draft, what we do. This is very important. So please focus. First information report, FIR. This is the first stage in a criminal trial. An FIR puts the case into motion. FIR is something given by the aggrieved person, the victim, to the police relating to the commitment of an offense. Then the second stage is after getting the FIR, the police comes into an action. The police starts to investigate. The filing of FIR and investigation is a long process. Sometimes it takes so much of time that it will be like 1 year. Yes, I'm right here. There are police stations where if an offense has been registered by the mode of an FIR, police can still be investigating the process even if it has been filed 1 year before. And there are matters where nothing has been done for almost 8-9 years. This is something our police is doing while we talk about the investigation. So this is something I'm talking from the reality perspective. But anyways, coming back to what this stage is. This a conclusion is to be made by the police that After collecting of evidence, examining various persons and taking their statements under 161 in writing and other necessary steps to conclude that what was written in an FIR and what the accused is saying, that the this certain offense has been committed on me, on my property, on my person, is does it actually happen? तो यहाँ पर पुलिस के पास ये जो पावर है, this is something very vast. Actually, police can do justice and police can do so much of injustice, and we as a lawyer play a very important role, because many times while drafting this FIR, what we fail to do is that we have written so many things like, agar if two people have fought and one person is injured and the other person is not, and that injured person is going to the thana, to the police, and is saying that this certain person has blown a danda on my head. So this is very important. When we are writing this thing, we have to conclude everything. We have to write each and everything very specifically to deal with it, so that it can help the police person while investigating the process. Anyways, I'll talk about this further when I'll be specifically talking how we will draft a complaint. So I'll move forward with this also, because I assume that you people must be aware about these stages also. And this session is specifically for the drafting. That's why I'll be talking about, I'll take more time while I'll be talking about drafting instead of spending so much of time in this, because I think I am spending so much of time and you people get bored with this. So now I'll be talking about charges. After investigation, police file a report. Either it is a closure report, which we call a FIR, and they say no offense has been committed, कुछ नहीं हुआ है, बस ऐसे ही ये फाइल कर दी थी FIR, or else they will file a charge sheet. The charge sheet should be filed within 180 days, although it depends upon the police how they are dealing with it, and the judges how they do it, because there are so many matters in the court, and actually India is taking so much of time while deciding so many matters. You people are already aware about this. Plea of guilty. Many times after the charge sheet is filed and the investigation officers claims that this offense has been committed and that this person should be proved, should be treated as a guilty person, that person can file a plea of guilty, being guilty, an opportunity to plead guilty, because actually the magistrate asks after the charges are framed or while framing the charges, do you plead guilty or not? This is very important. Do you plead guilty or not? Because I'll mention it from my personal experience that I have once seen a matter of the bounce check, where a person actually claim accepted that he pleads guilty, and later on he understood what he has accepted. So I'll narrate that fact to her. That person has given a check to the accused, the victim, whose check was bounced. So while doing so, while doing the framing of charges, the magistrate asked that person, "Do you plead guilty? क्या आपने इस चेक पे साइन किए थे?" तो उसने कहा, हाँ मैंने चेक पे साइन किए थे। क्या आपने इसे ये चेक दिया था? उसने कहा, हाँ मैंने इसे ये चेक दिया था। तो फिर आप मानते हैं कि इसकी पेमेंट भी आपके ऊपर थी, आपको इसे देनी थी? ही वाज लाइक, हाँ मैं मानता हूँ। तो ओवरऑल जब वो तीनों चीजें मजिस्ट्रेट ने उससे पूछी और उसने तीनों चीजें एग्री कर दी, ओवरऑल इट मीन्स कि आपकी गलती है। तो उसने कहा कि हाँ मेरी गलती है, बट यहाँ पर ऑलरेडी वो उसे वो पेमेंट चेक में दे चुका था, जिसके रिसिप्ट भी उसके पास थे।
जब ये सब हो गया, जब पूरा ऑर्डर लिख चुका था मजिस्ट्रेट, उसके बाद जाकर बाहर वो अपने वकील को से दिखा रहा है। वकील जब बीच में मजिस्ट्रेट को ये बात बोलना चाह रहा था तो मजिस्ट्रेट साहब ने उसको बोलने नहीं दिया. So this is something which is very important. This is here I'm talking about the relation of an advocate and a client. How innocently he accepted everything, although he had a defense, but he was not able to show that because there was not a tuning between the client and an advocate, and he pleads himself guilty, although maybe he was not. Now, coming to the prosecution evidence. After the charges are framed, the accused pleads guilty. Then the court requires prosecution to produce evidence to prove the guilt of the accused. The prosecution is required to support their evidence with statements from witnesses. The process is called examination in chief. The magistrate has the power to issue summons to any person as a witness or orders him to produce any document. Statement of the accused under section 313 of the CRPC. It gives an opportunity to the accused where he can explain that either he will admit all the facts or he can place his facts, he can come up with his thing, he can give his statement, he can say that this is not what actually this person is saying. So I'll move forward with the example that I was giving to you here. The matter in which I was talking about the bounce check and how that person unfortunately pleaded himself guilty, although actually he realized later on that he is not guilty, is that during the statement of him in 313, he could have been saved. But unfortunately, here I'll tell you an important thing is that the trial of summary cases, especially the bounce checks, is a summary trial where we don't have this procedure of 313 and everything. Once that person pleaded guilty in a summary trial, in a bounce checks in 148, 149, that person will get an order in that he have to pay that certain amount to the victim. So that case was over. Unfortunately, that person was very, very unfortunate. Now, moving forward to the defense evidence. First, the accused will give the evidence, his statement. Now, the defense evidence. And thereafter, analyzing everything after the final arguments, there will be a judgment. The judgment will be supported by the evidences, by the statements of the people. Now I'll be talking about the private complaint. Private complaint case is something what I was saying. When we go to Thana and the police refuse to register our complaint, then this is something we as a lawyer do. Many times we lawyer don't even go to police station. We just draft a complaint and send this complaint to the SHO, CC to the Deputy Commissioner of Police, Commissioner of Police. Now I'm talking about Delhi. And then we will move forward with 156.3 CRPC, read with 200. And we go to the court directly where this whole process can be taken followed up. What I have mentioned from the registration of FIR, investigation by the police, filing of the FR, final report or the charge sheet, then the charges to be framed, guilty or not, and then the evidence 313 and so on. Now coming to the summon cases. According to section 2W of the CRPC, those cases in which an offense is punishable with imprisonment of lesser than I think I'm getting some hand raises. Is there anyone who wants
Yes.
to ask something?
My own question.
Can you please note it down and we'll deal with the cases later on? Okay. So the stages of summon cases. Pre-trial, like I'll again assimilate this thing to you that the pre-trial stage is the trial is conducted in three phases. The pre-trial stage is the filing of a complaint, investigation by the police, and thereafter coming to the stage of charges where the judge decide either this offense has been committed or not, this person is guilty or not, and therefore if a magistrate finds that this person has not committed this offense, that person got the acquitted, a discharge. Actually, it's not called acquittal. It's basically called discharge. That all the charges filed earlier filed on him has been discharged. Thereafter, when the judgment is declared after the whole process of trial, the evidences, the statements of both the sides, 313 final arguments, when the judgment is delivered, it is called an acquittal. So, in summon cases, we have a pre-trial stage, FIR and investigation, then the charges, plea of guilty, and so on. I'm not repeating it just to save some time. Summary trial. Summary trial is a very short process. Again, I'll give the example of 148, 149 negotiable instrument matters, where the matter should be decided within 2 days from the filing of the matter. In those process, the court takes it very seriously, and actually, frankly speaking, the reality is, especially these matters, the roster is very high. There are almost all around 200 to 250 cases daily in the court of IMM, which is dealing with this sort of matters. So again, although there is a timeline of 2 years, the court is taking some more time to do so. The process is almost actually similar, although what I'll speak in brevity that in this process, at the end of investigation, a charge sheet is filed. It's called pre-trial stage. The accused person is then taken before the magistrate, who orally reads the particulars of the offense of the accused. In summons and summary trials, a formal charge is not written down. There, we are saving some time that the formal charge is not written down. The magistrate, after stating the particulars of the offense committed, asks the accused if he pleads guilty or not. What I have mentioned in that matter of a negotiable instrument matter, that the magistrate was asking that person, do you plead guilty? After asking three very specific and very particular questions, कि आपने पैसा आपके पैसे बनते हैं देने, आपको देने हैं, आपने चेक दिया था इसको, राइट? तीनों हो गए. इनोसेंटली ही सेड हाँ, क्योंकि सामने से पूछ भी मजिस्ट्रेट रहा है, वो वाली रेपुटेशन भी एक जज की होती है. Therefore, it goes on, and this is how very easily, very conveniently, a order, a judgment is drawn out. The magistrate, after stating this, if the person pleads guilty, the magistrate makes a record of the statement and then proceeds with the conviction and with the punishment that you have to pay out this much of amount. If you will not pay it, you will go to jail. It's very simple. In summary cases, the difference lies at the juncture. If the judge delivers a judgment of the conviction of the accused, the maximum sentence that can be passed for imprisonment is 3 months. So now I have almost covered how the process is going on in the court, in a criminal court. Now I'll be specifically talking about the first document which we as a lawyer prepare for our client, who is most of the time is a victim. एक बहुत दुखी इंसान हमारे पास आ रहा है अपनी प्रॉब्लम को लेकर. हमें उसकी कंप्लेन बनानी है, वो थाने जा चुका है, उसने थाने में हवलदार को, एसएचओ को, सबको बताने की कोशिश की है अपनी प्रॉब्लम, उसकी वो प्रॉब्लम सुनी नहीं है, या फिर उन लोगों को ये लगा है कि आप जो बोल रहे हो तो बनता ही नहीं है मामला। जैसे कि फॉर एग्जाम्पल, there is a dispute between two brothers. One was staying abroad and the other one staying here with the parents. Now parents have passed away and this brother has drawn out a document, we can call a will or anything, of the parents, and all the property is now in the hand of a brother who was living in India, and the brother coming out from the other country who is an NRI is asking about his share. And when he is going to the thana and narrating कि मेरे भाई ने मेरे माता पिता की will बनाकर सारी प्रॉपर्टी अपने नाम कर ली, यहाँ पर what will you say to this person? कि दो बेटे हैं, दोनों का सब कुछ इक्वल होना चाहिए, पर क्योंकि वो यहाँ नहीं था इस वजह से एक के पास सब कुछ है। Here specifically in this matter what police will say is that ये दीवानी मुकदमा सिविल का मुकदमा बनता है, आपकी कंप्लेंट नहीं लिख सकते हम, हमें फंसवाएंगे क्या आप? आपकी तो घर की बात है, संभाल लीजिए, देख लीजिए, इसमें कुछ नहीं कर सकते। So here our role is very important. Now you have to apply your mind and see how you are going to draft a complaint which has already been refused by a police station, that this is not a criminal offense, this is a complaint relating to a civil matter. Please हमारा burden मत बढ़ाइए. Go to civil court. So how will we draft it? I'll be giving some specific tips for it. And here I'll request all of you, while I'm giving these tips, while I'm stating the facts, how to do this. Okay, I'll also mention one thing. One more important thing is that facts are actually very important. While you are drawing a complaint or any draft in particular, is it either it is going to the police station or either it is going to the Supreme Court. Your draft is very important, your facts are very important, because it may happen that the SHO or the police station or thana wala person will not read you, but whatever you will draft, especially in the High Court and the Supreme Court, the judges are going to read it. They always do their homework, they always read what you write. So you should be very specific. Specifically, when you will go to the High Court and Supreme Court, the list of dates and the synopsis which you will make, and that is all about the facts. You have to be very clear with the facts, and these facts should be how these facts should be gathered from the victim, from your client. Here you have to do one thing which is very important, and you should specifically mention on that, is that hear your client with patience. अगर आपने उस टाइम उसको अच्छे से नहीं सुना तो उसको लगेगा कि थाने में भी मुझे नहीं सुना, आपसे पहले भी शायद वो किसी वकील से मिला होगा, उसने भी मुझे नहीं सुना, तो अब मेरे को कोई सुन ही नहीं रहा है, इस वकील साहब के पास भी मेरे को सुनने के लिए टाइम ही नहीं है। तो सबसे पहला काम तो आपको यही करना है कि यू हैव टू हियर दैट पर्सन, यू हैव टू हियर योर क्लाइंट, उसकी वेंटिंग पूरी होनी चाहिए, लेट all emotions comes out from that person, whatever he wants to say, try to note that down, so that he or she will be more happy that हाँ वकील साहब खाली सुन नहीं रहे, वो तो जो मैं बोल रहे वो लिख भी रहे हैं, ये तो अच्छे इंसान है. This will help you make your bonding with your client. This will create a trust between you and your client, which is very important. Like, I am still going on with the example of that advocate and the client, where he pleads guilty in a check bounce matter. Look किस तरीके का रिलेशन होगा, उन्होंने शायद सब कुछ सुना ही नहीं, अगर सुना होता तो डेफिनेटली he should have worked on the client. उन्हें उसे पहले ही बताना था कि भाई ये स्टेज है, जैसे कि मैंने आप लोगों को अभी सबसे पहले स्टेजेस बताएंगे कि क्या क्या होती हैं, क्योंकि सबसे जरूरी तो वही होता है। आपको क्लाइंट को भी उसी तरीके से प्रिपेयर करना है कि यू हैव टू टेल हिम कि कौन सी स्टेज क्या है। आज अगर हम कोर्ट जा रहे हैं तो आज होने क्या वाला है, यू शुड बी वेल वर्स्ड विद दैट ऑल्सो। सो मेक सम ट्रस्ट, हर हिम, और उससे भी ज्यादा जरूरी वेंटिंग ऑफ इमोशंस। जब वो इंसान कभी विक्टिम वाली स्टेज में आता है ना, तो उस दैट पर्सन नीड्स वेंटिंग। एंड यू पीपल हैव एनी क्वेश्चन, यू कैन रेज योर हैंड नाउ। व्हाइल आई एम स्पेसिफिकली डीलिंग विद द drafting, I will be happy to answer anything specifically regarding drafting or any technique, any tip which I am saying. If you have any question, like whatever, you can ask. Right now, you can ask that. Now, when you have assimilated all the facts from your client, तो उस टाइम पे that emotion which you have created between you and your client is that कि वकील साहब ने मेरी सारी बात सुन ली, उसके अंदर से सब कुछ निकल गया। बहुत बार a human only expect कि कोई मुझे सुन ले, मेरी हर बात सुन ले। उसके बाद you have to decodify that. How will you decodify that? कि आप rephrasing करके उनसे पूछेंगे कि मैंने आपको सुन लिया, मैंने आपको समझ लिया, now this is what you want. एक बार उसी टाइम पे हमें रीफ्रेजिंग करनी है when we are assimilating all the facts. उन्हें assimilate करने के बाद, although this is a tip which I am giving to you very specifically right now, is that कि I have written tip number 2 is that read the BEAR Act. आप क्लाइंट के आगे उसे नहीं पढ़ सकते हो, सो डेफिनेटली ये वाली स्टडी आपको पहले से करनी पड़ेगी. सो व्हाट यू विल डू इज दैट कि पहले से थोड़ा सा आइडिया रखो, अगर नहीं है तो डेफिनेटली ठीक है उसी टाइम, बिकॉज यू पीपल विल बी वेरी यंग व्हेन यू विल कम टू कोर्ट. यू कैन टेक आउट योर BEAR Act एंड रीड एंड कैन हाईलाइट दैट हाँ मुझे पता है ये प्रोविजंस हैं, ये सेक्शंस हैं जो आपके बनते हैं और इसमें इतनी इतनी सजा मिलेगी, क्या आप इसके लिए तैयार हैं. Be very precise at that point of time. While drafting a complaint, you will specify this to the person that this is the complaint you will be drawing. आप ये बोलेंगे, आप ये बोलेंगे तो ही ये ऑफेंस बन रहा है, अगर आप ये नहीं बोलेंगे तो ये ऑफेंस नहीं बनेगा. You have to specify that thing. जो बोलेंगे, what I am saying is that कि I will not say कि आपको अपनी तरफ से कुछ फैक्ट्स बनाने हैं. प्लीज डोंट डू दैट, कोई फायदा नहीं होता है. मैनी टाइम्स इट टर्न्स आउट समथिंग very bad, very terrific, and you get ashamed as a lawyer in front of the court. क्योंकि जो बातें नहीं हुई है घुमा फिरा कर अगर आप वही बात अपने क्लाइंट से बुलवाएंगे तो उसका फायदा नहीं है. पर स्पेसिफिकली कुछ बातें होती हैं which you will get to know through venting. जिस टाइम पे वो क्लाइंट रो रहा होगा और आपको अपना पूरा नरेशन दे रहा होगा, you will get to know that this is something which is an offense which can be utilized by this person, and through this mode, through this mechanism, you can take that person in your hand in the criminal court. For example, I'll move forward with the dispute which I was saying about the brother. The one is NRI and the other one was staying with the parents. If there is any will and that will was not drawn out by the parents, you can see the chart, the signatures, you can see how this is given, when this was given, when it was made, is it registered or not. This is something you have to do. You have to be very specific with it and you have to work on it. So it is very important to work on your subject, on your material. You have to be very precise. You cannot write everything in your complaint. Now, on the next slide, slide number 26, I have written what a good complaint consists of. This is and how you will draw it. In this lecture, at least if you are reading if you are listening to me, if you are reading this PPT, I am 100% sure that you will be able to draw a best complaint. You will be able to know what you should write in a complaint. And look, when you will go out of the college, you will become a lawyer, or you are in the fourth or fifth year of your LLB, there are people around you who must be having some dispute. Like if you are living in a flat, you can have a dispute or regarding a CCTV camera, regarding the parking, or so on. There are so many disputes, so you can go out and can start drafting these complaints for people. So it is very easy to draft a complaint, but you have to be very precise, very specific, very accurate about the facts. So how will you write to the SHO? सबसे पहली कंप्लेंट सबसे पहले SHO को ही जाती है, स्टेशन हाउस ऑफिसर, जो भी आपका थाना बनता होगा उसमें. उसके बाद you will write the subject to register an FIR against. अब now look at this subject against, जिसको भी accused बनाना है, whoever you want to be the accused, you have to write their names specifically, their names, their address, father's name, phone number, everything. You have to provide everything to the thana so that they can talk. Otherwise, if you will not give all the information, they are very lazy, they won't go. So if you have given the phone number, the email, they will actually try to communicate. Then you will write, sir, ma'am, whoever that person is. Yes, I'll also say that while in the subject, when you are asking to register an FIR against, you can avoid writing the sections because they already know what they have to draw. अगर आप स्पेसिफिकली लिख देंगे यहाँ पे कुछ, तो अगर कुछ एक्स्ट्रा भी बनता है आपके फैक्ट्स के हिसाब से, आईपीसी का कोई प्रोविजन या किसी और एक्ट का कोई प्रोविजन, तो वो बहुत स्पेसिफिक हो जाएगा, क्योंकि आपने स्पेसिफिकली सबसे पहली कंप्लेंट के अंदर क्या बोल दिया है कि रजिस्टर एन FIR अगेंस्ट दिस अंडर दिस. You are now very limited. You should not be limited. You should just give the name of the accused against whosoever you want the complaint to be lodged, the FIR to be lodged. Now, the point number 1 will be I, the person who's drawing the complaint. Who are you? Complainant कौन है, क्या करता है, क्या करता है, you want to write or you don't want to write, that's your call. Just be very specific. I, son of this, daughter of this, resident of this, and number, and that's it. Now moving forward, on the very next para, after explaining yourself, you will say what happened, हुआ क्या था, why you are drafting this. सीधा आपको आ जाना है हुआ क्या था, on the incident. After writing the incident, you will say how accused did it. How accused did it means you have to assimilate the chain, the modus operandi, how they committed it. You have to explain it. For example, I'll say it like this: the brother forged the will, fabricated the documents, and have get it transferred in his or her name. His or her name, his name, daughter-in-law, his wife, and whatever. So this is how you will link that chain. मैं ये बोल रहा हूँ, मैं ये बोल रही हूँ, उसके बाद मेरे जो जमीन जायदा जो भी पर्टिकुलर प्रॉपर्टी है, इसके ऊपर ये रह रहे हैं स्पेसिफिकली, एंड देन कैसे रह रहे हैं, इस तरीके से मेरी इस पोजीशन का इन्होंने ये फायदा उठाया. यू हैव टू लिंक दैट चेन विद द क्राइम. नाउ इट इज वेरी इंपॉर्टेंट टू रीड द बेयर एक्ट. द बेयर एक्ट is very must. You have to know, like there are illustrations, there are examples in our bear act only where they are specifically talking about how a particular offense is committed. Like if you will say abhadrata, modest, against the modesty, or you are assaulted. So what is an assault? अगर आपके इसके इंग्रेडिएंट्स को और अच्छे से स्पेसिफाई कर देंगे तो दैट विल मेक द होल एपिसोड मोर क्लियर कि ये स्पेसिफिकली हुआ था. अगर आप उसको एक या दो वर्ड के अंदर लिमिट करके लिखेंगे सो यू विल फाइंड इट आउट दैट कई बार क्या होता है ना कि वी हैव गिवन अ कंप्लेंट और उस पर एफआईआर हो भी जाती है. Yes, it also happens. And what the police officers specifically do is they will make all the bailable offense in that FIR. आपकी FIR हो गई, उन्होंने काम कर दिया आपका, लेकिन आपका काम हुआ भी नहीं. This is also what happened. So you have to be very particular. You have to read the verdict. You have to write down each and everything very specifically. And I'm also giving this tip to you. Whenever you go to the thana, work on the complaint. कभी भी ऐसा मत करो कि आप थाने चले गए और वहां पर एसएचओ ने आपकी बात सुन के ओहो सही में लग रहा है कि आपका तो कुछ आपके क्लाइंट के साथ तो कुछ गड़बड़ हो गई. आप ना वकील साहब ऐसा काम करो 2 मिनट में एक छोटी सी कंप्लेंट बना कर दे दो और हम आपकी एफआईआर रजिस्टर कर लेते हैं. आप बड़े खुश, आपने दे दी, हाँ भाई हो गई, 2 धारा लगा दी बेलेबल ऑफेंस की, कर लो क्या करोगे. एंड दिस इज एक्चुअली हैपेंस. दैट्स व्हाई यू हैव टू बी वेरी पर्टिकुलर. आप कौन हो, आपके साथ क्या हुआ है, मोडस ऑपरेंडी क्या उन्होंने यूज किया है, यू हैव टू स्पेसिफाई. लिंक करोगे चेन्स को. व्हेन आई वाज नॉट हियर, my position was abused, my parents were for ill, or is what I was trying to communicate, but I was not able to do so when I was trying to come here. I'm still narrating the facts with the perspective of those two brothers. The one is NRI and the other one is living here with the parents. So how his condition was abused when he was trying to come. The younger one was saying, no, you don't have to come, I'm taking care of my parents, they are my parents, they are your parents, we are a family, and everything was very jolly and very kind. And he was like, wow, I have such a nice brother, he's just like a Bharat, and everything. But everything was very. So will write this thing के अंदर, वो बहुत खुश हो जाएगा. अगर वो खुद से इस चीज को ड्राफ्ट करेगा तो वो अपनी यही बातें लिखेगा जिनसे उसे कुछ नहीं मिलने वाला है, पुलिस वाले पढ़ेंगे नहीं, एंड दैट विल मेक इट अ फैमिली डिस्प्यूट. हेलो, is my voice not clear to everyone? I've
No,
just
ma'am,
got
you
this
are audible.
message.
No, ma'am,
Hello?
you are audible. No, ma'am, you
Oh,
are
Ma'am,
audible.
ma'am, you are audible. Your voice was breaking a little bit.
बीच बीच में
okay,
गायब हो रही थी मैम
that
आवाज.
must be because of some network problem. So while writing this grievance, if you will write these 1 or 2 lines which your client actually wants to write, जो उसकी प्रॉब्लम है, जो उसके इमोशंस हैं, जो उसका हर्ट है, he'll be very happy. Wow, this वकील साहब is very good. आपको हर चीज को स्पेसिफिकली उस जगह वहां पर इस तरीके से लिखना है कि यू हैव टू ड्रॉ द एग्जैक्ट ऑफेंस so that police cannot say कि ये हुआ है. You have to say that this position was abused, and thereafter assimilating all these things, you will be writing your that codified line that in the interest of justice you are required to take cognizance, register a speedy, free, fair, unbiased trial and everything to deliver just and proper justice. This is how you draw a complaint. Now I will also tell you what is the importance of this complaint. आपकी इसी complaint के basis पे FIR lodge होगी, इसी के basis पे आप statement देंगे, इसी के बेसिस पे आगे जाकर आप एविडेंस प्रोड्यूस करेंगे. एविडेंस भी आपको इन्वेस्टिगेशन के टाइम पे जब आपकी एफआईआर रजिस्टर होगी उसी टाइम पे पुलिस वाले मांग लेंगे. सो यू विल मूव फॉरवर्ड विद दिस कंप्लेंट थ्रू आउट. आफ्टर दैट, once the trial is finished and that person is acquitted, then you will go to appeal on the basis of your complaint only. And on the basis of that appeal, you are also going before the sessions court, before the high court, before the Supreme Court. So you can understand this is the very basic and very important draft, which should contain each and everything very specifically. You have to jot down every fact, you have to take care of everything, how you are going to deal with the police officers in your first two paragraphs, how you will make out the modus operandi, link the chain of the commission of crime, so that you will be very specific. And this is the difference. You will show, you will say that a layman, the client was going to the thana and was saying ki mere register kar lo complaint, and now you will go with these 2 or 3 paragraphs and the police have to register your complaint because you are very specific. देखो ये हुआ है, ये मेरे पास document है, the forgery has been committed, this is not a registered document, this is this, and you have to specify these things. You have to note down the grievance, and then you have uh, one more thing I'll tell you is that you should go with your client. If you can, you should go with your client to the thana. This will give a confidence to the client, and you will also get confidence. In the young age, either you are a girl, either you are a boy, you should go and talk to the SHO.
Sorry to disturb you, ma'am.
Ma'am, you are not audible.
Not audible.
Ma'am, hello.
Just give her a minute. कुछ network issue होगा. It will get resolved in a minute or two. I think there is some network glitch from ma'am's end. Just wait for 1 minute. It's getting resolved.
Hello, is it audible and visible to all?
Yes, ma'am. Now.
Yes, ma'am.
Okay. I continue with the complaint. I am specifying what will happen when you go to the thana with your complaint. You have drafted your complaint with all the essential things which you should be very specific with. That the police officials will read only the 2 or 3 paragraphs or complaint. They don't want a big complaint. So the first two paragraphs should be about the incident and how the offense was committed. The third para is the grievance which your client wants. उसके साथ जो हुआ है उसकी कहानी भी, उसकी 2 लाइन लिख दो, वो भी खुश हो जाएगा, उसको भी खुश करना है, पुलिस वालों को भी टैकल करना है. And then what you want, that will be the last para where you will not write the provisions, the sections specifically. Initially, when I used to write down the provisions, the sections of IPC or other offenses under which I wanted the complaint to be registered, but now I have learned we don't need to do that. What we have to do is write down कि I will continue with the example of those two brothers. He'll say, forgery कर दी मेरे साथ, so please register a complaint that forgery has been committed, fabrication of documents have been committed, and the wrongful loss, the cheating. You will specify those things, those ingredients, which you will read from the BEAR Act, and you will specify them only. So that if there is scope of anything other, you can add that in your statement, which you will give to the police station while the investigation is going on your complaint. When they will call you, when they will call the accused, that time you can add any further things. So don't limit yourself. Never specify the IPC or other provisions in your complaint. If there is some scope, if there is more venting, if there are chances that some other crime or some other offense could be committed, don't limit yourself. Then moving forward to this is what I'm saying. If you'll go with the complaint and the police officers are ready to lodge your complaint, this is how you should go. But many times, almost 90%, the police officers don't register a complaint and don't lodge it as an FIR. So what is your remedy? Your remedy is that now you will go to the deputy commissioner. You will go to the deputy commissioner, give him the complaint, and will take his receiving. He will ask the SHO to investigate, to do the thorough investigation again. Then he will give his report to the DCP. This is how they deal. Now, moving forward, there can be chances that even after giving the complaint to the DCP, nothing will happen. So what you will do? What you will do is that you will give a complaint to the Commissioner of Police. Like in example in Delhi, SHO, the Deputy Commissioner of the specific district, and then the Commissioner of Police, Delhi. Earlier in UP, there was this SHO, SSP, and then the DGP. Now in some specific area like Ghaziabad, Noida, Lucknow, there are also commissionerate, there are also commissioners. So now that is something you have to see if you are living in the NCR. This is how they are dealing with it. And specifically, particularly if I'll be talking about UP, Haryana, wahan par you have to draw the complaint in Hindi. How you will do that? I can also give a tip for that also. Read it out, try to translate, and there also be very specific. And more than Delhi, if you will draft a specific complaint in UP, they will register it. They will register. There are more chances your complaint will be registered in UP. You just have to translate and you have to be very particular that the first two paragraphs of your complaint should cover the commission of the offense very particularly. And even after giving the complaint to the commissioner, if nothing is happening, so I'll be talking about our practice in Delhi. What we do is we draft a complaint, today is a Saturday, I'll draft a complaint tomorrow. I'll go on Monday to the SHO. I'll go to the DCP the next day. And on the same day, I'll go to the commissioner. I'll wait for the 3 days and then I'll go to the magistrate court for the registration for the cognizance of my complaint. Now here on PPT page number 28, I have taken example how we drafted. This is a very basic, very rough example, but still I wanted to give a impression to you people. And this is how I was able to assimilate it, to give you this impression, to give you this that in the court, you have to specify in which court you are filing the complaint under 156.3. This is PPT page number 28. Complaint case number, court fees, if you have to specify, although it's not done here, but I have also mentioned because this is something you have to do. Court fees bhi lagti hai usme, so just so that you can remember, isliye I have written it. Affix the court fees stamp of rupees, almost 10, 50, 20 rupees done is okay with it. Complaint under section, read with 200, 156.3. I have also taken the example of this offense 323, hurt, and 506. Again, how will we draft it? आपके पास already आपकी complaint है, आपने उसके अंदर सब कुछ लिखा हुआ है, वही यहाँ पर specifically आ जाएगी in the form how we will draft it in the court. सब कुछ वही होगा. You have already worked. आप वही चीजें repeat करेंगे. अपनी complaint के अंदर आप लिखेंगे. Complainant कौन है, who's the accused, what happened, any witnesses. Here you will also specify the witnesses in your draft if you have any. Then when the complaint was filed, आपने कब complaint file की to the SHO, when it was given. If you have sent it through the post, you have to affix the postal stamps and your further grievance. Again, you will write the prayer to register, and what your prayer will include is to register FIR, take cognizance, trial. You will also write about the jurisdiction of that court, and that court is good to go with it. This is how we work, and the whole process of investigation will start on the instance of the magistrate. The magistrate will take the cognizance. That magistrate will look forward how to do that. Now here also I'll give you a tip. What we do is, आप already complaint दे चुकी हो, SHO, the police, the thana already know what your problem is. So now when you have a case in the court, this is a complaint case. So what you will say is, please ask them to file a fresh status report. I don't want to know what they have done in the earlier process, because you have already dealt with the DCP and the commissioner, and they have some report with them where they have written something about the commission of the offense, how it is committed, is it a criminal offense or not. For example, again, if I'll take the example of those two brothers who are fighting for the property of the parents, how one has taken control over the whole property, is that the police will again say it's not a criminal dispute, it's a civil dispute. So how you will deal with it is like, you will specify that, and specifically you will say, I don't want that status report, I want a fresh status report to be filed. I don't want your action taken report, your earlier ATR. And usually the magistrate always order for a ATR, and you have to say, no, I don't want a ATR. What action they have taken, I don't have to do anything with that. Now I have come to the magistrate, so I want a fresh status report to be filed. Always call for a fresh status report, no ATR. This is specifically you have to say. This is something coming from the pleadings. what you will plead before the court. Because many times the magistrate say, अच्छा आपने कंप्लेंट दी, मैं मंगा तो रही हूँ, मैं मंगा तो रहा हूँ ATR, पता कर लेते हैं क्या किया है इन्होंने, कैसे नहीं किया, कुछ ना कुछ तो किया होगा, आपका केस शायद नहीं बनता है, क्योंकि 156(3) के अंदर भी अपने केस को रजिस्टर कराना, उसको मेंटेनेबल कराना is a task which you have to ease with these specific tips, with this specific counts. You will learn this thing when you are young. So what you can do is go to the court and learn this art. There are specifically tips and tactics which the advocates always take while dealing with the police officers. They are also very thorough with these process. उनके पास दिन के ऐसे 5-7 मुकदमे आते हैं, एक आईओ के पास ऐसे 20-30 मामले होते हैं, उनको बहुत अच्छे से पता है कि हम उन्हें इस चीज को कैसे घुमाना है, तो उनके बातों में, उनके प्रोसेस में घूमने से बहुत बेटर है you better know what are the provisions and how you can get your relief in your way. Be very specific, be very particular with that. Your prayer will include to register an FIR, to take cognizance, start trial, and punish the accused. This will be very simple, very basic thing. So what I am doing here is that I am very precise, I am very specific. This is something what you will write and you will get the relief. Don't go for so many facts. Don't make your thing so vast so that कोई उसे पढ़ने को तैयार ना हो. पुलिस के पास भी बहुत सारा काम है, मजिस्ट्रेट के साथ भी बहुत सारा काम है. अगर आप बहुत स्पेसिफिक टू द पॉइंट बोलोगे तो वो सुन लेंगे, तो उन्हें याद भी होगा और उन्हें भी लगेगा अच्छा चलो हमारा काम तो बच रहा है, इसके अंदर बहुत सारी फाइल्स नहीं पढ़नी, बहुत सारे पेज नहीं पढ़ने, सिर्फ 2 पैराग्राफ लिखी है, 2 पैराग्राफ में सब कवर किया हुआ है, इतना तो हम कर लेंगे. दिस इज व्हाट यू कैन डू. Now again that complaint, the whole trial will begin. Now, not going to that trial, I'll be talking about how you can draft a bail under 437. Because I have kept in my mind while creating this module for you, what I want is आपका एक basic draft, the complaint. You should know how to draft a complaint. Then how to draft it into a 156(3) petition. You should know that what particular you should have in your head while drafting, what particular tips, while particular lines and paras should be, because there is a chronology which we have to follow. That in the first paragraph you have to introduce the person who is writing this, जिसके behalf पे वो draw हो रहा है, then how it happened, the modus operandi, the link of chain. This is very important. You can remember it and you will be very happy. आपको कॉपी करने की जरूरत नहीं है, because आप कितना भी पैरोटिंग करो, आप कितना भी कॉपी कैट बनने की कोशिश करो, in drafting this thing is not going to help you. Never. You have to analyze these things, you have to be clear, you have to listen to your client, and you have to apply your own mind. Criminal drafting is all about applying your own mind on the facts. You can't move beyond the facts. And even while dealing with the drafting, we say even the Supreme Court is a court of facts. Supreme Court is also a court of facts because they are coming to the court and reading your list of dates and events and your synopsis. So whatever is the basic of a matter of the complaint is very important. You have to be very, very particular and specific. Now I'll be talking about how you can draft a bail. I've told you how to draft a complaint, how to draft a 156(3) petition, an application before the magistrate, your complaint case. Now I'll be telling you, if a person is in the jail, how you can get a bail for that person. Like you must have heard this thing. Bail is right, jail is exception. Bail is a basic right of every person. Every person should get a bail. because until the person is proved guilty, that person is deemed to be an innocent person. This is how our country, our code, our Indian Penal Code was drafted. Definitely, now the three new laws are coming, and most probably they'll be applicable in the Union territories in Delhi from the December 2024. This is what they are saying. So you have to move on with that also. But now particularly I'll be talking about the IPC. So this is the provision. Though if it is going to change, so there will be a different section for this also. But for right now, we can move with this. Under 437, we opt for the bail before the metropolitan magistrate. I'm specifically talking about Delhi, so it will be like this. सबसे पहले कोर्ट का नाम होता है, फिर उसके बाद इन द मैटर ऑफ जो स्टेट होता है उसका वर्सेस जो भी अक्यूज्ड है उसका नाम, specifically in the corner of your A4 size paper. Yes, now we use the A4 size paper, not the legal paper as we used to do. FIR number, under sections, the FIR has been registered, the police station, accused under custody since. This is very important. You have to mention this. Application under 437 CRPC for grant of bail on behalf of accused. यहाँ पर when you will write about the accused, you have to be very specific. ऐसा हुआ है, इवन ऐसा एक मैटर हाई कोर्ट में भी आया था जहां पर दो सिमिलर नाम के अक्यूज थे, उनके फादर का भी नाम सेम था और मोहल्ले का भी बहुत ही माइनर सा डिफरेंस था, तो एक अक्यूज जिसको रिलीज करना था उसकी जगह किसी और को कर दिया. So you have to be very specific with this. It actually happens. बहुत ज्यादा crowded है हमारे jail. So you have to be very specific. Now I'll be coming to the body of the bail. How you will draft it. Again, even in the bail, in the drafting of a bail application, few things are very particular. You have to write it down. This is how we draft a bail. Like that the present FIR has been registered on false and bogus facts, because many times actually it do happens. Facts stated in FIR are fabricated, concocted and without any basis. Then the second will be that the police have falsely implicated the applicant and arrested him in the present case. The applicant is a respectable citizen of the society and is not involved in any criminal case. The facts stated in the complaint against the applicants are civil dispute and do not constitute a criminal offense at all. Because now I will be telling you how to get a bail. If the brothers wala case, the complaint has been lodged, but again it's a civil matter. When the money angle is involved or some civil dispute is involved, it is very difficult. And I'll also tell you one important thing is that in every civil matter, you will find out a lawyer who will get a criminal case invoked against the client. And in a criminal case, there will be very rare chances where a civil case will be made out. Like अगर दो लोगों की लड़ाई हुई, किसी ने किसी का सर फोड़ दिया, तो ये सिविल डिस्प्यूट नहीं हो सकता. लेकिन जो एग्जाम्पल अभी हम लेके चलते हुए आ रहे हैं अबाउट द टू ब्रदर्स, दिस इज एक्चुअली अ सिविल मैटर, बट यू हैव स्पेसिफाइड इट. पुलिस समझ गई दो लाइंस के अंदर कि हाँ हाँ ये तो हो रहा है, वो क्योंकि उसने वो क्राइम कमिट कर दिया है. This is also a fact. But again, because the bail is rule and the jail is exception, so there are chances that person will get the bail. आप उसे जेल में नहीं रख सकते until and unless कोई बहुत स्पेसिफिक चीज उसकी अगेंस्ट आपके पास हो, जिसके अंदर आप बोलो कि इसकी जुडिशियल रिमांड चाहिए, इसको कस्टडी चाहिए. दैट इज द पॉइंट नंबर 4, that the applicant is not required in any kind of investigation, nor any kind of custodial interrogation is required, nor any recovery is to be made at the instance of the applicant. तो उसे क्यों रखना है आपको जेल में? Please release that person. That applicant is having very good antecedents. He belongs to a good family. There is no criminal case pending against them. or him if it is for a specific person. Now coming to the next slide. The applicant is a permanent resident. There are no chances of him absconding, that the applicant undertakes to present himself before the police when directed, that the applicant undertakes that he will not directly or indirectly make an inducement. These are the specific language, specific lines which we use in our bail application. Bail application के अंदर तो specifically हमें blah blah चीजें नहीं लिखनी होती हैं. You cannot write so many things. You have to be very specific. इसी वजह से यहाँ पर जो चीजें, जो points मैंने highlight करके लिखे हुए हैं आपकी slides में दिए हुए, these are very specific things. If you write this much in your application is sufficient, because actually it is covering each and everything. The applicant further undertakes not to tamper with evidence, because these are the few things which the police always say कि इसको custody में लेके जाना है, या फिर हमें ये कि ये tampering of evidence कर सकता है या abscond कर सकता है. तो you will note that down. We are taking it down. We are filing it with the affidavit. We will not do that. अगर करेंगे तो आप कंटेम्प्ट ऑफ कोर्ट में तब पकड़ लेना, लेकिन अभी तो रिलीज करो. दैट द एप्लीकेंट शैल नॉट लीव इंडिया without the permission of this court, then as may be imposed by the court or the police in connection with the case. You have to also write this down, because you have to say you are surrendering before the court. कोर्ट जो बोलेगा आप वो करोगे. अगर कोर्ट आपको छोड़ देता है तो then again there will be the prayer. It is therefore prayed that the court may order for the release of the applicant on bail in the interest of justice. Any other order which the court may deem fit and proper in the facts and circumstances of the case may also be passed in favor of the applicant. And the applicant through the counsel, applicant के sign through the counsel नीचे, फिर उसके बाद counsel का नाम उसके sign. This is done. This is your bail application. Now I'll be giving few more tips which you should keep in your mind. The bail format in India is filed after the arrest of the accused by the police. अभी एक recent matter हुआ है, सुप्रीम कोर्ट में था, where the senior advocate was appearing, जहां पर अरेस्ट तो पुलिस ने किया ही नहीं. That person has applied for the bail. वो बेल उसको डिनाई हो गई. सेशंस कोर्ट में हाई होने के लिए मैटर गया. उसने बोला कि यहाँ पे तो अरेस्ट हुआ ही नहीं है. I don't know why they are pleading. And what they said कि जिस तरीके से जजेस जुडिशियल ट्रेनिंग के लिए जाते हैं, इसी तरीके की किसी जुडिशियल ट्रेनिंग के अंदर इसे भेजना चाहिए एडवोकेट्स को.
Ma'am, you're not audible.
अरेस्ट तो हुआ ही नहीं, आपने बेल कैसे अप्लाई की है? और उसने जाकर खुद सरेंडर किया है अक्यूज ने. हेलो हेलो.
Ma'am, your voice was cracking in between. Now it's clear. You can repeat if you want.
Is that audible now?
Ma'am, your voice is cracking.
Okay, so I was giving an example. My voice is again cracking.
It's fine now.
Okay, give me 1 second. I'll reconnect my AirPods. Hello?
Yes, ma'am, it's fine now.
Okay. this is what happened. You have to
Ma'am, it's again breaking.
very particularly have very clear your facts so that you can understand the person your client, ask your client to the answer, and actually I'm not a person, that person is himself.
Ma'am, you are visible now.
Is them audible also?
Yes, yes, ma'am, you are.
Okay. I'll move forward with the tips. That this is how we move forward. That there should be an arrest, only then we will file a bail. If the no arrest has been made, we don't need to move forward with the bail. So the arrest is very important. The bail format under section 437 can be filed by any close relative also, जिसको हम पैरोकार बोलते हैं. अगर accused जेल के अंदर है and that person cannot come and sign that document, that doesn't means कि अब उसको bail नहीं मिलेगी. उसका कोई close relative being a पैरोकार उसको साइन कर सकता है. मेमो ऑफ अपीयरेंस फाइल होता है काउंसिल की तरफ से, and you can move with the bail. No court fees is to be paid if the person is in custody. The details of the FIR, name of the accused, father's name should be properly mentioned in the bail so that the jail authorities are able to identify him properly after the release order from the court. जैसे मैंने एग्जाम्पल आपको बताया था कि this should be very particularly kept in mind that the names, the address, father's name, everything should be given very particularly. Now, अगर arrest हुआ ही नहीं है, but there is an apprehension, then you can file anticipatory bail. There is the provision of anticipatory bail under section 438. This is just like how we dealt with the bail. Everything is similarly written in these slides also, so I'll be skipping it. Now there will be again the same prayer application, and I'll be coming to, there will be there is no difference between these tips and the tips for bails except particularly is that when you are applying for anticipatory bail, an affidavit in support of bail should be filed, readable copy of the FIR if the FIR is lodged, relevant documents, and why you think that this anticipatory bail should be given to you. You have to specifically note it down that you are a decent person and you are falsely fabricated so that they can put you behind the bars. Just to skip these things, you will specifically mention these things in the anticipatory bail. This is the slight difference between the basic regular application of a bail and this application. Now I'll be coming to the question of the FIR before the High Court. How you draft a FIR? Because I have told you how to draft a complaint, how to get it lodged into an FIR through 156.3, and how you will be dealing with it. Now, if there is some certain sort of compromise between the parties, how you are going to deal with it is like, I'll be telling you how to draft that index of the anticipatory bail. It is like you will draft a notice of motion. This is a very basic application of notice, urgent application, 2 lines application, the court fees, the memo of parties, list of dates and events, application, annexures, and a wakalatnama. This is the procedure we follow while drafting a question petition. Now I'll be talking specifically about how to draft that question petition. While drafting a question petition, you have to be very particular, like you have to write ki this is the FIR which was lodged under this section in this police station, and also praying the honorable court what happened between the parties. So you will be very specific while drawing a question petition. You will say that there are no grievance between the parties left. They have amicably settled their matter. No coercion under no influence. You have to specifically write these points also. Then you will be talking about the statement of the complainant, who will be taken on record by the judge also, that अभी आप लोगों के बीच में कोई ग्रीवियंस कोई डिस्प्यूट है कि नहीं है. Once it will be given, consent देगी वो party, and then at least a cost of rupees 50,000 is imposed while questioning a petition. Mostly it happens exceptionally, it's in the hand of the court what they do. They impose some sort of cost. This court always go in some charitable organization, like they can plant trees, can go into the relief funds of PM, of the CM, or disaster management, fire department, or whatever. It can, these funds always go to the help of some person for some noble cause. You will specifically write down everything that, and these points, these lines will be specifically written in a question application. A question application is very simple. I have already noted down the specific provisions, specific clauses which you have to add. So this is how you can get a FIR quest in an high court. Only a high court can question FIR once it is lodged. Or else, yes, there is also an alternate. When the charge sheet and the trial has not commenced, then the police officer can file a FR, which is called final report, the closure report, and they can also close that FIR if the matter has been settled between the parties. Like there are compromise between the husband and wife, the compromise between the family members, the brothers, the dispute relating to the property, or any cheating or forgery or fraud between the business partners. There are so many matters which are getting settled in even in the mediation centers, and people are opting for the question of FIR. They always mention the question of FIR in those settlements also. Now I'll be talking about how to improve it, how to improve your drafting. That the very what you can do is write down the facts from the judgment, so that you can move forward. The judgments should be read, the leading judgments. I'm talking about the leading judgments. Read the leading judgments, the leading cases, where you can point out what were the facts taken in record by the judge, what were the issues. Once you will be done with it, you will be able to decodify that this is something I have to write in this particular matter, and the judge is going to listen to me. This is the issue if I'll raise before the court in 156(3), and the judge is going to listen to me because this is what happened in the Supreme Court, this is what happened in the High Court. You have to have a good vocabulary. To have a good vocabulary, you can read books, you can also read through the judgments. The judgment is the basic and very important thing which you can do. Read judgments, note down the words, and therefore you can assimilate a diary, a personal diary of yours, where you will be learning a word, legal words every day. So reading a judgment is the most important and crucial thing which will be beneficial throughout your career. You can find out each and everything from those judgments which you want to decodify in your complaint, in your drafts, and improve your grammar. That is also very thing to be a good expert in drafting. Then finally, what I will say is that you are going to learn drafting till the last day of your life. जो ड्राफ्ट मैंने 1 साल पहले बनाया था, I won't say कि वो ड्राफ्ट मैं आज बनाऊंगी या मुझे वो आज पसंद आएगा. This is a lifelong journey. You are going to learn it through your own experience, through your own mistakes. You will learn from your own mistakes. So just do that. You will learn, you will grow, and you will improve. There is scope of improvement every day in all of us. So I'll be done with my lecture. Now I am open to questions you can ask me.
If any student has questions, they can unmute themselves and ask it. Arpit Yadav, you have raised.
Good afternoon, ma'am. Good evening, sorry. Good evening. What allows the anticipatory bail?
If you have exhausted all the remedies which you alternately have, if you have gone to the sessions court, if you have gone to the high court, then they will entertain you and they will decide it on the spot. You have to follow the mechanism.
There would be certain exceptions for which it allows to do so.
Yes, that's what I'm saying. You have to exhaust all the remedies, and only then it will be entertained. Otherwise, it will be dismissed on the spot.
Okay, thank you.
Any other student, Himanshu? Please go ahead.
Ma'am, after filing a complaint to the SHO in police
Yes.
station, and when we are filing 1563, is there any time limit?
No, there is
for
no
filing
time limit. But once you have
1563?
filed a complaint before the SHO, then if they will do anything, they'll call you within 1 or 2 or 3 days. You will get a diary number. If they are not doing so, then you will go to the DCP. You will give your complaint to the DCP, and then you have to give your complaint to the commissioner, because they have a wide power under section 36 CRPC, and thereafter you can file your complaint under 156(3). This is the mechanism. You have to go to the SHO, DCP, and then the commissioner.
Ma'am, is there any limitation after registering an FIR? I have registered an FIR before 5 to 6 years ago, and now I am filing 1563.
No, there is no exception. And again, you can also give a complaint. You can again give a complaint of yours, and you can file your 156(3) on the basis of that fresh complaint also. if they have not done anything.
So opposite party has an defense, na ma'am, ki you are not filing the complaint in 1563.
No, that's not an exception. That's not an exception, and that is not at all a defense. This will go in your favor only, that almost for 5-6 hours you were waiting for the police to do something, but they were not doing so. So that's why finally you have decided to come to the magistrate.
Okay.
Any other query?
Yes,
Sagar
ma'am. I have. Okay.
and Glory. Okay, Glory, please go ahead.
Okay, so ma'am, I had a question that in district courts, that is original court, that under the CPC 1973, are we allowed to quash the FIR? Or for quashing it, like you need to approach the next upper higher court in hierarchy?
For the question of FIR, you have only remedy, that is the High Court under 482 CRPC. A sessions court cannot quash a FIR. FIR can be quashed only by the High Court.
Okay, okay, thank you, ma'am.
Welcome.
Sagar, yes, please go ahead.
Good evening, ma'am. Myself Sagar Ambika Pandey.
Good
डाउट में मेरा डाउट ये था कि क्रिमिनल केसेस में जो अगर सेटलमेंट हो जाती है,
जी
वैसे तो होती नहीं, अगर सेटलमेंट हो जाती है तो क्या कंप्लेंट या जो FIR होगी वो क्वैश हो सकती है?
एक्चुअली होती है, मीडिएशन में भी हम लोग कराते हैं। जो डिस्प्यूट हस्बैंड एंड वाइफ के बीच में होती है, मैट्रिमोनियल मैटर्स जिन्हें हम बोलते हैं, उनके अंदर नंबर ऑफ लिटिगेशंस होता है, मल्टीपल लिटिगेशंस होता है। 498 हो गया, उसके अंदर डोमेस्टिक वायलेंस हो गया, क्रुएलिटी हो गया, डाउरी हो गया, बहुत कुछ करते हैं उसके अंदर, बहुत तरीके के केसेस होते हैं, और इवन उसके अंदर रेप केसेस भी होते हैं। तो वो सब अगर फैमिली मैटर डिस्पोज्ड ऑफ होते हैं, दिस इज द वाइट पावर इन द हैंड ऑफ द हाई कोर्ट. इट इज देयर कॉल, बट फॉर द सेक ऑफ जस्टिस दे ऑल्सो नो कि किस तरीके से क्या प्ले किया जाता है इसके अंदर. जजेस टेकिंग दिस ऑन देयर हेड, दे डू क्वेश्चन इट.
मैम ये अनएथिकल नहीं हो जाएगा फिर?
दिस इज द कॉल ऑफ द हाई कोर्ट.
ओके मैम, थैंक यू सो मच.
वेलकम.
Any other question? Anyone else having doubt? I think no one has raised their hand. So much for such an insightful session on criminal pleadings.
Welcome.
I'm
Thank you
sure
so much,
the students
Swati
must
ma'am.
have learned a lot, and hoping to see
Thank you
more
so
of
much.
you in next certificate courses. It was such a
Sure,
pleasure
sure,
learning
ma'am.
from you, ma'am.
We'll be happy to meet you, and I have in one exercise for all of you.
You can
On the
share it.
last slide, on the last slide of the PPT,
Okay.
I have written.
Please. I'm sharing the screen. Yes, ma'am. This is the last slide. I have shared it for with the
Okay,
students.
so I skipped that. I'll share that with Swati ma'am,
Sure.
and I will want that you people to draw a complaint on a particular subject, so you can analyze what you have learned and what you can draw. You people can exchange your notes and can improve with that on the same subject. And it was nice talking to you all. It was a wonderful
Same here,
evening with all.
Sure, ma'am.
We'll meet you soon again for some other session.
Definitely, ma'am.
Have a happy weekend.
Thank you so much, ma'am.
ma'am.
Welcome. Bye.
Bye, ma'am. Thanks. Students, I will be sharing that exercise with you. And for final submission of assignment, you can submit it along with the assignment that I will be giving you. Okay, now I'm ending the meeting for everyone.